only from you, this bailiff removal, and there's no signature even on this letter.
Because I've got the warrant against you to collect that 42184. If the council wants me to collect £1 million,
right, but
I'll be saying to you it's £1 million.
But can you take the properties without the warrant being signed or without my permission? Or money? Can you take the money? Can you take the money without me signing?
Remove your asset or collect money on behalf of the council. I'm the only person in the whole of the country that's allowed to take any money from you at this present time.
But I can't give you money unless I've got security as in signature and liabilities, because I believe this is wrong. I don't want to come through you.
If I collect any money from you, you'll get a receipt from me with my signature on it to say that I've collected whatever it is from you.
So that means that you'll be accepting liability. If it's wrong. Yeah, just if it's wrong, because the same thing is, I always thought and assumed that a warrant of execution would always be signed, so there's come back to work out if the judge has been defrauded. But as you say, we don't go to a court, we go to a building which is another business, and somebody else has made a decision with the council, and then they have employed you, which is just business. But no one's taking liabilities when I'm saying it's wrong.
The only person allowed to take any money from you at this present time in the whole of the UK is me.
Right.
So there's another bailiff of equity came to your property tomorrow.
Right.
Started demanding his £421. It would be illegal.
Well, that's what I thought. It's like me asking you for that money without backup.
The only person that's allowed to take any money from you is me.
And under whose authority?
The council.
So you're working for the council, not the court? Not the court's authority? You're working for... That's a limited company.
The council comes to court to get a court order.
Which is a limited company.
And handed to Equita,
yeah, but then...
and then the warrant is given to myself as the court bailiff to go out and collect money or remove goods from you. Yeah,
but what I'm saying is, they've given you authority to act for them over me, and I've been trying to argue it. Don't worry, we'll get to the bottom of actually paying this, but I need to actually show you have the authority for me to hand over the money, and I'm not handing over to Nottingham.
I wouldn't come to your property today if I didn't have the authority to collect the money from you. I wouldn't be having this conversation with you trying to collect the payment from you. I wouldn't be talking to you about all this ins and outs about it if I wasn't allowed to take any payment from you.
Right, but unfortunately, while we're going on this, we've got to sit down this paperwork, but what I'm saying is, I've informed you that I don't want you to come to property, because this has caused so much stress with my wife. I really am almost having a meltdown over this. So if you do, or anybody else, for Equita, it's aggravated trespass. Would you be willing to commit aggravated trespass, or shall we just deal this with paperwork and no other way?
Why don't you just sort out the £421.84?
I couldn't do that without actually being able to eat.
I give you a receipt for the £421.84. And then you can take whatever action you want to against the council, against Equita, and against me personally, if you wish, at a later date.
Okay, but...
At this present time, nobody wants to listen to you. Nobody wants to speak to you. The only person that's allowed to speak to you at this present time is myself.
Okay.
So until you pay £421, nobody's going to listen to you.
Okay, so if I haven't paid you, say, by Tuesday, Wednesday, or something like that, and would you still be willing to step on my property even though I've told you I would follow you through for aggravated trespass?
I can stand on your driveway right now if I wanted to.
Right, well, if I actually tell you can't, then, of course, isn't that a criminal act when you've been asked to leave?
No, it's not. I just ignore that, and I can stand right on your property right this minute if I want to, because there's a court order in place.
Right, in which case...
You can do whatever you want to.
In which case, I'm not sure that that's actually lawful, so I'm going to have to take this to the police, because if you say you can stop there at any time, they can confirm whether you can do that with an unsigned warrant, but I think it actually might be a criminal act, or what you're talking about. I don't think you can come onto my property if I say no.
£421.84.
Yeah, but you're ignoring me. Yeah, I'm trying to work out that if, however we proceed on this, are you willing to actually stand on my property, even though I told you not to, which is a criminal act? Which is a criminal act. Yeah.
I could drive to your property right now and stand on your drive right now.
Even if I asked you not to. Could I also then issue a Form 4 complaint against you?
You can do whatever you want.
Right, because if you are on the property, I'm going to have to do that. So, and call the police.
You can do whatever you want, and it'll be a complete waste of time on your part, because legally I'm allowed to stand on your drive.
Right, not if I've asked you to leave.
You can't.
Would you like me?
There's a court order that allows me to stand on your drive.
Right, well, you know I'm now doing the internet, and I know this is clear because it's case 1QB557. If a debtor strikes the bailiff over the head with a full bottle of milk after making a fourth entry, that's in the property, yeah? The debtor is not guilty. But on my property, I can only get you arrested if you're actually being threatening, and I'm not threatening. If a person strikes a trespasser who has refused to leave, I'm not guilty of an offence. But I don't want to do that. My brain, at the moment, I'm feeling very defensive.
I can stand on your drive any time I want to, because I'm allowed to under the warrant.
Yeah, but can I use reasonable force to remove you from my property? Because this is where I lose it. I really sometimes lose that idea of what it is, and it is down to, I was in the army in '83, yeah, and I was up to some very, very strange things, and it's all meant to have gone away. It's even hard for me to get therapy on this, because, you know, post-traumatic stress disorder. But I'm worried about my own mental health.
Like, listen, to be honest with you, if I'm standing in your drive right this minute...
Yeah, and I ask you to leave and you don't, can I do that to your house? Can I come round to your house and do that and not leave?
You haven't got a court order to go to my property.
Right, a signed court order.
You haven't got an order to come to my property.
No, but you haven't got a signed court order either. You've got a piece of paper you keep telling me signed.
Stand on your property.
And you're telling me that court order, unsigned, allows you to come onto the property.
Listen, in theory, you could phone the police, right?
Yeah.
Get a policeman standing outside your drive.
Yeah.
Okay. I come to your property at, say, a set time.
Yeah.
I come and stand on your property in presence of the policeman.
Yeah.
And you try and push me off that drive in
right.
any way, shape or form.
Yeah.
And you're the one who will get arrested.
I see. But you will have a signed court order. Not an unsigned court order. I can print anything without a signature on it, liability.
If you try to touch me in any way, shape or form, push me off your drive.
Really scared. Stephen, I'm getting really, really, really scared. I thought the law said that I would comply with things if I had the liabilities served against me in a court of law and a signed warrant. But you're telling me you don't need a signed warrant. You're acting as a court bailiff or a private bailiff?
Listen to the voice now that I just sent.
Yeah, sorry.
Listen to the message that I recorded for you. Listen to that again.
Yeah.
That's a personal message to you. I've got no interest in removing your goods.
Right, what I've got...
Listen to that message. So all this stuff you're talking about...
I will do, but I'll finish then.
It contradicts that message. So if you listen to that message again, that thing that I told you...
Yeah, but...
that'll put your mind at rest.
That's fine, but I'm worried that you might be making a mistake because a debtor can remove the implied right of access by displaying a notice at the entrance. This is endorsed by the Lord Justice Donaldson, the case of Robertson, yeah? Akin to closing the door prevents that. A debtor can be also remove implied rights of access to a property by telling him to leave. But I've already told you to leave, so if you turn up, is it not aggravated trespass? Is it aggravated trespass or not?
You're getting wound up, so I'm going to have to terminate this call.
I think you better. But aggravated trespass, I will treat as aggravated trespass because...
But you're getting aggravated, you're raising your temper again.
No, I don't mean to. It's that I do have some issues when people are telling me that I can't have any paperwork. There's no signature or authority. Okay, Stephen. No problem. You have a good day then, and I'll try and speak to you again. I'm sorry, Stephen. You got a bit aggravated. Now, how did we do with that? Good. Yeah.
Debt Free TV in association with GetOutOfDebtFree.org.